Prior to filming, before we started filming, my good friend Farouk here, over to my left, struck me squarely across the jaw just before filming. If you breach it now, or you are reported as having breached it, you're heading towards 28 days prison.
Oh, wow.
With almost no conversation. It is the truth. He hit me. It's the truth. He financially abused me. It is the truth. She emotionally abused me. It is the truth. She hit the children. It's the truth. You are now fighting the truth.
So basically, you need to pull yourself together. You're now in the trenches. Once you've had these documents served on you, you are officially in the trenches. Your job is now to survive. So I would say harness your energy instead of the anger and the frustration. Harness your energy into the longevity of how you're going to survive and get through this. That is my advice to you. Good evening and welcome to Disqualified Dads. Time is short, so I'm not going to talk too much. We're going to jump straight into it. I am in sort of not deep north, but some way up north to see Mr. Ryan again. And we're going to be talking about non-moles. A lot of you have been asking about the non-molestation order. We're going to go into it, the ins and outs of it, what it is, what it means, how to tackle it, how to deal with it, what to do, what not to do. Before I carry on, just a quick one. Please subscribe, share, and follow the channel. We're trying to get this information out there. I'm nearly up to 1,000 subs. So please just hit that subscribe button. Right, Mr. Ryan, time is short, so let's dive straight into it. Since our last podcast, a lot of people have been asking me about this non-molestation order. Many people don't understand it. Shockingly, surprisingly, I've met a few fathers that haven't had one, so which is a bit surprising as well. And they're wondering what it is. And there's those out there, obviously, who have no knowledge of the family court. When they're suddenly hit with it, what the pattern I've seen is they get hit with it, they read the statement of allegations. If you're not from a criminal background, you see court orders, there's a little bit of panic and anxiety sets in. Suddenly you're being told you can't see your kids. Well, it doesn't say you can't see your kids, but you can't go near your home. Potentially homeless, you can't go near the ex. And it says on the non-mol, you can make contact to see the kids, but when you do that, she claims she feels threatened and you end up inside. And obviously that paranoia of not seeing your kids plays on your mind. You end up at the school gates. Next thing you know, police is carting you away because you're a monster. Now, first and foremost, what is a non-molestation order?
Okay, a non-molestation order is an obstacle. It is a legal obstacle that one party can put in place to block or obstruct the other. It's a gateway. It's a gateway to criminal proceedings. So what happens is, let's give an example. What's happened? So a party, be it mum or be it dad, a party goes to court and claims domestic abuse. This is the favourite. Claims domestic abuse. And the court considers whether a non-molestation order should be put in place. A non-molestation order is a legal vehicle whereby that party, the party who has made the claim, can be protected. And that protection comes in the form of a court order. That court order carries within it a number of articles that are designed to stop the other party from being able to impose risk or impose threat on the party who is feeling abused. So the norm in terms of a non-molestation order, you can't go within 100 meters of the party who has the non-molestation order in their favour. You can't go to their address, their home address. You can't go to their place of work. You can't go to the school where the children go. You can't go to an address where you know they might be. Those are the kind of the big 4 or 5. Now, over and above that, in terms of non-molestation, the single biggest issue that people don't fail to understand is that non-molestation, as I said at the outset, is a gateway to criminal proceedings. Because you decide to ignore it, and you decide to go and see the other party because you're a reasonable individual and you feel it's appropriate to just go and approach them and have a chat. They phone the police. The police have a record of your non-molestation because the court's lodged it with them. The police immediately turn up, arrest you, and you find yourself in a custody suite. That's non-molestation.
Right. So let me break it down even further for you laymen's out there. Dan's explained what it is like in somewhat legal terms. Now, from my understanding, 9 out of 10 times it is a mother, let's use the word mother, a mother normally applying for a non-mol, and 9 out of 10 times a mother will get it secured. 9 out of 10 times. Would I be correct in saying that? Just to
Yes,
people
you
aware?
are correct in saying that.
Right. And the other thing is, when you said that you're not allowed to approach that party or go to their home or workplace. Now, this home could have been your home prior to this non-molestation order. Let's get that clear. You could have been living together. You come home, you get an email, WhatsApp message, a letter literally through the post serving you this non-mol. Once you've been served that and you've acknowledged it, you're no longer allowed in your own home as well. I just want to clarify. So just because it's your home, you go back there, you're potentially homeless when served a non-mol. Am I correct in saying that, Mr. Ryan?
You are correct in saying that. Yeah, as I say, that is the implication of a non-molestation.
And as Mr. Ryan said, the gateway to criminal proceedings. Now, this is where the serious bit comes in with the non-mol. If you breached a non-mol in any way, even if you don't breach it, let's put it bluntly, even if you don't breach it, but mum phones the police saying she feels threatened, because it says on the non-mol you can make contact with mum to arrange access to the children, but mum's read your text message saying, can I see the kids this evening? That might be enough to make mum feel threatened. She calls the police. Because police have it on their record there's a non-mol, they will come and get you, they will take you away. It's as simple as. Am I right in saying that?
That is it. That is it. And then the matter has the potential to escalate, because you then find yourself in a position where you're in a custody suite, and you're being grilled by a police officer or two police officers if you're really lucky, and they are asking you why it is that you deliberately breached a non-molestation. Now, off the back of that, regardless whether you did it or didn't, that almost doesn't matter. Off the back of that, one of two things is going to happen. Either you are going to have the matter taken back to family court, and you are going to be accused of breaching a non-molestation, and that will lead to some issues, which we can talk about shortly. But the graver issue is that those police might decide that your breach is so heinous, so horrendous, that they decide to escalate your non-molestation into a criminal matter, which is a restraining order. So you find yourself in custody suite for a couple of days. Next thing you know, you find yourself in front of a magistrate. That magistrate is told that you have breached a non-molestation order, that you have put the other party at risk, the other party has felt threatened by your behaviour, whatever it may be, including the totally innocuous text saying, can I see my children? And the magistrate decides, well, I'm not going to mess about with this matter. I'm simply going to escalate the non-molestation to a restraining order. A restraining order is no longer a family law matter. A restraining order is a criminal matter.
Okay.
The minimum restraining order is usually 3 years. The same rules apply. You can't go within 100 meters. You can't go to the address. You can't go anywhere where you know they are, except here's your problem now. If you breach it now, or you are reported as having breached it, you're heading towards 28 days prison.
Oh, wow.
With almost no conversation, because you're now breaching a criminal prosecution. The other issue you've got in terms of restraining order is you now have a criminal prosecution. That could impact on your work, that could impact on your life, that you now have a criminal prosecution because you have been criminally prosecuted and you have a restraining order in place. I have in the past had cases where my clients have had their non-molestation escalated to restraining orders, and possibly the worst case was a guy who happened to bump into his ex-wife, and that's the reality, in a supermarket by pure chance. She left the supermarket, having not said a word to him, went outside, rang the police. The police turned up 5 minutes later. They arrested him. They took him to a custody suite. He spent 3 days in a custody suite. He went straight into a magistrate's court. They handed him a 4-year restraining order and 400 hours of community service and a £700 fine.
Wow.
He went back to work. Work said, where have you been for 3 days? Because he was in a custody suite. He advised them he'd been in a custody suite. This has happened, that had happened, the other happened. They dismissed him.
So now he's jobless as well.
He's now jobless. He's got a criminal record. For the next 4 years, he can't go anywhere near his ex-wife, which basically means he can't go near his children.
Kids, yeah.
And he's locked out.
Right, it's worse than I thought. Okay, so look, the restraining order now brings a different element to it, but let's not dwell on that too much for now. I don't want, don't want people getting too upset or whatever.
No, indeed.
Right
Let's
now.
go back to non-mol.
So the restraining order is, look, it's once you breach it. So look, as I've said to people before, and correct me if I'm wrong, obviously, relationships broken down, things are a bit heated. Someone's advised you to miss his 9 out of 10 times. Because look, the fact is, if a father applies for a non-mol, the chances of him being taken seriously are very slim, as we discussed in the last podcast we had, is very slim. So the chances are mum might get badly advised by someone to say, look, you want to take control, become the resident parent. In order to do that swiftly, quickly and easily, and by securing legal aid, we need to claim abuse. So when you claim abuse, the non-mol sort of falls nicely into it. Legal aid lawyer will advise, let's do a non-mol. You secure the property, secure residency, secure the children, and also I'm making 4 or 5 grand here. I mean, who cares? That sort of thing. So they then obviously fired his shot straight away. As a father, you're in emotional turmoil. You're going through trauma. You don't know when you're going to see your kids. Your whole world's been turned upside down. As I mentioned, patience is your best friend. Sit back, do nothing. Do not make contact. Do not call her. Do not text her. Don't send your mate round. Don't send your girlfriends round. Don't send a family member round. Do not do anything. Keep well away. That's rule number 1. As painful as it is, best thing to do is be patient and keep well away.
Exactly.
Now, beyond that, Mr. Ryan, what steps do they need to take now? What is the next step after being patient and keeping away now? What is a litigant in person, or the person receiving this order, what should they do next?
Okay, well,
what are their options?
Let's take a step back for a minute, because non-molestations, we'll cover this point just very quickly. Non-molestations arrive in one of 2 ways. They arrive on notice, or they arrive ex parte. Let's understand what that means. On notice means that a party applies to court for a non-molestation order. You, as the other party, are advised that they have made the application, and the 2 of you go to court. It gets thrashed out in court, and you get it or you don't get it. That is an on-notice non-molestation. So at least you have some opportunity to have your say.
Right.
But I'm going to revisit the likelihood of that in a minute. But the majority, far and away, the majority of non-molestation applications are made on an ex parte basis. What does that mean? What that means is the person making the application is stood in the court explaining to the judge the various allegations that they wish to make. Where are you, as the other party? You're nowhere to be seen. You're not in the court. You're not in the street. You're not in the car park. It's because you don't know this is going on. This is all happening without you even being aware. The first you know about it is when the non-molestation lands on your doorstep, because it comes in the post, or more likely is when a bailiff knocks on your door, or an agent of the court and says, I'm just going to hand you that. So on notice, ex parte.
Right, okay.
But flipping forward then back to the point of where do I go now? Okay, so you've got a non-molestation in place. Absolutely right. Rule number 1, don't try and challenge it by going off around to find mum or dad, depending on who owns it. And I just need to talk to you. Let's be reasonable. That is never going to work. Stay away. And Frog is absolutely right. Patience is your friend, unfortunately, when it comes to the family court. So you need to wait. You need to wait until you are handed the opportunity to challenge it. Every non-molestation, regardless of whether it is delivered on an ex parte basis, i.e. you didn't know until it landed on your doorstep, or is delivered on an on-notice basis, the person who's getting it, the person who's being handed it, the person who's been handcuffed with it, gets the opportunity to challenge it, normally within 28 days. Although sometimes, because the court is so broken,
it could be 2 months.
Yeah, it could be 2 months,
up to 2 months,
3 months, 5 months,
2
and
years.
so the list. We have 2 years in some instances, and so the list goes on. But the reality is, let's kind of stick with the norm. The norm is within 28 days you will get opportunity to challenge it. What does that mean? What that means is you'll be invited into court. And a judge will look at you, or a magistrate will look at you and say, well, you've got the non-molestation. You will have had the copy of the application, so you know what's being said, you know what's being alleged. What do you say about that? Now, that gives us another problem. And that other problem is the commodity of truth in the family court.
Okay.
When something is uttered or alleged or spoken out loud in family court, in my experience, and I will be challenged on this point by many people, but I'm telling you how it is from my perspective. In my experience, the moment that statement is made, it is the truth. He hit me. It's the truth. He financially abused me. It is the truth. She emotionally abused me. It is the truth. She hit the children. It's the truth. You are now fighting the truth.
Yeah, yeah.
And you have got to unpick the truth. And that's where non-molestations fall down. That is where the bulk of non-molestations, when they get challenged, still in place at the other end of the challenge. Because the court's view is, I've never met you before. I've never met you before. I have to decide what I think is safe for all people concerned, and primarily the children. Consequently, regardless of whether you tell me that the person who is making these allegations is lying through their teeth, I still have to take the safe option. And the safe option is believe them.
Yes, so the courts and the judge's position is normally, especially if a mother has made allegations against a father, and a father, how can I put it, he's obviously, because of the societal positions we're in, there's an element of mum is a victim, father potentially has capability of violence because he's a man, whatever that societal position is that we have of men and women. They will just say, he's a big lad, he'll survive. Let me just not take the risk or put my name to it. Even if the judge believes, guess what? I think this guy's completely innocent, but would I put my name to it?
Yeah.
They're not going to risk it. That's the reality. And father's non-mol is potentially 9 out of 10 times, whether it's the truth or not, whether he's put a great case, evidence or not, they will stamp it off for the 12 months. That's the reality.
It is. It is.
And I just want to highlight the three processes of the non-mol is the three options you have when you challenge it is either you vary the order, discharge it, or you accept it. Now, let's just talk about, just want to make sure we cover all points. So, okay, so father's received it, he's read through it, he's thrown up, he's come back, read it again, maybe thrown up a couple of times more, but then he's looked at it and said, right, you can either vary it, discharge it, or accept it. Now, as someone who has no family court experience, he has no knowledge of any of this, my rule number one is do not go to a solicitor. They will scaremonger you more and use your anxiety to fleece nearly, I would say, at least $5,000 out of you on the spot. So do not go to a solicitor or a barrister. Don't listen to what anyone says. You can either represent yourself or go to a good Mackenzie friend like Mr. Ryan here. Now, Mr. Ryan, if he's a litigant in person, say for argument's sake, that's his three options. Firstly, let's say he is innocent, he's not done any of it. Should he then, on the application, say, I am applying to discharge it?
He'll receive a document in the post which tells him that you've been given the opportunity to challenge this non-molestation. And sometimes, to be honest, it really does depend on the court, because some courts use the document, some don't. Sometimes there will be a reply notice on the back of the non-molestation that says, what do you intend to do? One, do you, exactly as we've just said, do you intend to accept it? In which case, just sign the form, accept it and get on with your life and accept the fact that you'll never go in that street again. Or do you intend to challenge it by varying it? So I accept some of it, I don't accept all of it. So I want some, but I don't want all. And that can be sometimes, I accept that I won't go to the house, I won't go to the street, but I want to be able to go to my children's school.
But does that also mean, let's not clarify, does that also mean I'll accept it, I won't go there, I don't want to see your ugly mug anymore anyway, but I didn't do any of this, just to highlight, I'm not accepting these allegations. Does that also mean that?
That is a separate process that we call undertaking.
Right,
so,
okay.
So you'll go to the court, and as I say, so that instance I've just given there is vary.
That's
so I
varying,
go to court
right.
and I say, I will accept this non-molestation, but I want it varied. I want the terms of it varied. I want to be able to go to the school. I want to be able to go into that street because my mum lives next door. or whatever it might be.
Okay.
So that's variation.
Before you go on from
Yeah.
variation, let's just cover all bases. So
Mm.
that is okay. My mum lives around the corner there. I
Mm.
want to be able to go to my mum's house or my doctor's
Mm.
or my local mosque,
Mm.
church, whatever. Yeah.
Yeah. Mm.
But that doesn't apply to the kids, does it? Because straight away, more than likely, if you've got a non-mole, you probably ain't seen the kids, and the chances are this is going to be used for you not to see the kids. So, is there any basis of an argument to say, but I want to be able to see my kids or not, or is that just a fantasy at this stage?
No, you can have the argument. The percentage odds are stacked against you. Invariably, a non-molestation feeds the child issue.
Right.
And feeds the court's view that we need to explore what's going on here before we decide whether you are fit, safe, responsible, all of those wonderful words that we need to apply to parenthood. Before we decide you are fit to continue to be a parent. Because I say there's this interesting stance in court where they say, well, we need to establish whether you're fit to be a parent. Well, hang on, I already am a parent because I've got my children. You're just stopping me from seeing them while you decide if I'm fit to be one. So it's a slightly different process. But that's variation. So to say, you're basically saying, there are certain things I will accept, but there are certain things that I won't accept because it's going to compromise my life.
Okay, so that's accept, vary, and then the third
and then
one?
The third one is
undertaking.
Yeah, as I say, it's undertaking or full acceptance. Full acceptance is, yeah, I did it. It's me. I can't argue the point. And you just get it handed to you. Get on with your life. The other option you have is called an undertaking. Now, what an undertaking is you accept the conditions, you accept the sanctions. So I accept the fact that I won't go in the street. I accept the fact that I won't go to the school. I accept the fact that if I see her heading towards a supermarket, I'll go to a different supermarket. I accept all of those, but I don't accept liability for what it is that she or he has said that I have done.
Why?
So what the court will then decide, if they believe that the allegations are superficial enough, if they're not too serious, the allegations being made, they will say, well, okay, will you accept an undertaking? What an undertaking is it's a promise to the court. You are no longer subject to a non-molestation if you accept an undertaking. The non-molestation is discharged, removed,
right?
But you have an undertaking. And what an undertaking is, in the simplest terms, it's a promise to the court. I promise to this court that I won't go in that street. I won't go within 100 meters of the house that I used to live in, but I don't now because I'm not allowed.
Also, could be the house you own as well.
It's irrelevant. The house that I own, I pay the mortgage on, and I used to live in. Now I won't go anywhere near it, and I won't go near the street, and I won't go in the supermarket. So you accept a series of sanctions under a promise, which is called an undertaking. So that's the variations. That's the sort of the options and the 1 to 6 of in terms of non-mol.
All right, so let's just clarify it again. So either you can accept it, sign it, and say yes, guilty. I accept all conditions, and I don't care. Number one. Number two, you can ask to discharge it completely and say, I didn't do any of this. I'm not having it. This is abhorrent. This is a challenge to my human rights. This is disgusting. I will challenge the whole lot. So you can ask for a discharge, complete discharge. You can ask for an undertaking, as you said, where you say, yes, I will accept the conditions of the non-mol, but I do not accept any of the allegations made against me, but I still will follow the rules of the non-mol, but the non-mol won't be in place. Non-mol's gone out the window. You just say, I'll observe by these rules. And then you've got the variation where you accept some of it, but you don't accept the other bit. As in, does that mean I'll accept some of the allegations, but not all of them?
No, you're accepting, a variation is you're accepting some of the conditions.
Conditions, so
but
not the allegations.
But not all of them, no. The allegations will go one of two ways. If you say, I don't accept this order, number one. I don't accept this order because I don't accept the allegations. The court, at this first hearing that you're now having where you're being given the opportunity to challenge, the court will say, what don't you accept? Well, I just don't accept any of it. I don't accept the fact I ever hit him or her. I don't accept I ever hit the children. I don't accept I ever stole money. I don't accept I ever controlled them financially, psychologically, sexually, or whatever. I don't accept any of that. The court will then say, well, then fine. We have no choice but to go to a contested hearing.
Right, okay.
A contested hearing is, so we're now heading towards hearing number 3. Hearing number 1, let's just recap. Hearing number 1, the application is heard. You may be there if it's on notice. You may not be there if it's ex parte.
Right.
Hearing number 2, your first formal opportunity to challenge, where you say, I'll promise to the court the undertaking, or no, I'm sorry, I'm not having this. I didn't do any of this. I'm not prepared to be labelled with this. So I'm just challenging everything that's been said. At that point, the court then said, well, okay, well, we only allocated an hour to this today. So we're now going to go to a contested hearing.
Right.
A contested hearing can be anything from half a day to a day. And it is where we explore each of the allegations that have been made in detail. Now, remember my earlier comment. When spoken, it is true in the family court. So you will have handed to you, let's say 5 for the sake of an example, you'll be handed to you 5 allegations that have been made against you. And bearing in mind that because they've been uttered and stated in family court, the family court's view is that they're probably true. Because the onus of proof in the family court is on the person making the allegation, formally. So the individual who said, I'm accusing you of domestic violence, when they get to the contested hearing, they are required to prove that. Now let me tell you what reality looks like. Reality in the family court means the person who has made the allegation, all they have to do is deliver a credible account of what happened. So prior to filming, before we started filming, my good friend Farouk here, over to my left, struck me squarely across the jaw just before filming. I was upset. It brought tears to my eyes. I think there's probably a mark. If there's not, don't worry, I'll make one. And I was horrified, and frankly, I'm traumatized. I've been to my doctor. I'll be ringing him later. He'll be recording the fact that obviously I was hit, that I'm traumatized by that. I've made that allegation. What'll happen now when we go to a contested hearing is I'll just say, yeah, I didn't do anything. And then he just hit me. Here, it was here. I had a red mark. I can't talk about it anymore. I'm too upset.
Yeah.
Prove otherwise.
Yeah, and if it's unfortunately, a mother who looks frail and weak, crying and wailing, a bit hard to sort of, and then you got some mug like me standing there. It's a bit difficult to judge. I did this. No one's going to believe you. It's very difficult. Yeah.
It is very difficult. It is very difficult because in this instance, what am I going to do? I'll tell you what I'm going to do. I'm going to get my phone out and go, have you seen one of his jiu-jitsu videos?
Yeah, it's game over.
There we go. Thanks very much. I don't need to say any more. He's just been found guilty of a domestic abuse. He's guilty of the fact that he punched me. That's it. Non-molestation cured. So truth is a commodity in the family court. Once it's said, it is true.
Right. Let's go to a short break and we'll come back and continue. Right, we have some idea of what the non-mol order is and what to do and what those 1 or 2 or 3 hearings look like. Now, as you know, Mr. Ryan, in the family court, the solicitor, barrister sort of terrain, there's a lot of sharks and leeches out there. I've known fathers now have gone into court, they've got caught up with these solicitors and barristers, paid 4 or 5 grand, they're in court to... Also, I'll just highlight, in the first hearing, if you're just going to challenge it, nothing much is going to happen. But the solicitor will sell you a barrister, they'll sell you the dream, we need to do this, they'll play on your fear. And 9 out of 10 times you go in there saying, yes, this is my name, yes, I am that person, and I'm challenging it. And then you go home. And you've just paid nearly 2.5 to 5 grand for that. They won't tell you that. You could go in on your own and just do that. You don't need anyone. So just make a note of that. Now, the second thing is, right, so I've had a father go in with a barrister, and what the barrister advised this father to do on his first hearing, I think, with the non-mol is he said, just accept it. Now, unfortunately, father being new to this whole family court business, he accepted it to his demise. And what happened was 10 minutes, it was wrapped up, left. His barrister took 2.5 grand. Solicitor made apparently this big bundle for it. 5 grand later, he's now accepted it. Now, what happened was, if I'm correct now, they said it won't make any difference to your child access. But the problem is once you accept the molestation order and accept the fact that or some of these allegations, it affects your child access all the way through. And if you have a fact finding later on, it will implicate that and affect that. Am I correct in saying that? So my point is this: if you are not guilty of the allegations placed against you, should you accept it, or what should you go for? So knowing what we know about the family court, knowing we understand the chaos, and once it's uttered, father's being landed with this, what should he do? What is his best option?
Fight it.
So go for a full challenge, discharge. You try and challenge it. So your best option is to go for a full discharge, regardless of the outcome. Go for the full discharge.
The problem with non-molestations is the bulk of them in the family court currently are issued on an ex-parte basis, so you don't even know. The first you know about it is when it hits your doorstep, or the bailiff knocks on your door and says, "I'm just going to give you that," which means you're already on the back foot. You'll then go to a solicitor, as Brooks rightly says, and the solicitor says, "Listen, we'll sort this for you. What we'll do is we'll go to the challenge hearing, and then just because we want to get this out of the way in order that we can focus on the child matter, because obviously it's about getting your kids and seeing your children. So let's get this out of the way. So we'll send a barrister with you." And you're absolutely right. The barrister will cost you anywhere between £2,000, £3,000, £4,000, £5,000. And he will say to you, she will say to you, "Okay, the easiest thing for us to do here is just accept it. Just accept it. Because then we just get it out of the way. We show that you're a reasonable man. You're not looking to waste," and I'm using man as the example, "you're not looking to waste the court's time. You just want to put this to one side and let's focus on the children because that's what's important." Okay, here's the mistake with that. What you've just done is you've just handed a sizable sum of money to a man or a woman who is going to stand in family court and is going to tell a member of the judiciary that you're an abuser.
Yes, bad move. You are being finessed. Yes, it may be hard to believe, but you are being finessed. Do not fall into the trap. There are hundreds of fathers who have fallen into this. So right, you've got an non-mole. Leave off completely, lay low, be patient, do not approach the ex, don't try and be clever, don't send a mate round, don't do anything, stay away. Patience is your best friend. Hold it together. I know it's not easy. Second thing, you will go to the application form or whatever it is. On the non-mol it says apply to discharge it fully. That's your second step. You'll go to those one or two hearings, potentially the contested hearing. And then after that, 9 out of 10 times, the reality is this, that it will get stamped off more than likely for 12 months. Not in all cases, but most cases, the judge will not take the risk, especially if you are a father. They will stamp it off against you. So get on with your logistical situation. You need to survive. As I've mentioned, live out your vehicle, sleep in your office. If you like me, used to do night shifts, you sleep at work, you shower at work, shower in the gym. Hustle, survive, get by. You need to hold it together. Now, right. So if the non-mole is, just want to highlight this point. If the non-mole then gets stamped off after 28 days, and you tell the judge, "But judge, this is my home. I have nowhere else to go." Can that be a reasonable argument? And will the judge look into that? What is your option? Because I mean, I know firsthand as a father, you are literally thrown out into the street. I mean, look, you'd be lucky to get a hearing first. So let's say he's lucky enough to get a hearing. 28 days is in front of the judge and says, "Judge, look, I can try and take whatever option you offer me. I want it discharged. But the reality is I've got nowhere else to go. I will be on the streets." What happens in those cases?
I'm resisting the temptation to say the judge doesn't care. The judge's sole concern is the safety of the party and the children where allegations are being made. So the judge might have a degree of sympathy with the fact that you may have nowhere to go, but he or she will offer the response that you need to lean on family and go and find yourself a family member to live with because you are not going back to that home. And my concern as the judge, my sole objective as the judge, is to safeguard everybody in this matter. This individual over here has made some allegations. I need to safeguard them by keeping you away from the home. So, with all due respect, your lack of home is not my problem.
Yeah, so look, it's harsh. I know, look, it's horrible, it's harsh, but you need to pull it together. You need to survive. Okay, Mr. Ryan, is there anything else we have missed or we need to talk about around the whole non-moral and how that will tie in maybe with your child? Okay, sorry, this is what I want to ask you. I
Go
remember
on.
now. So, along with the non-moral, when you challenge it, you submit the form that's with the non-moral to say, I want it discharged. Is there any other form? Because I remember, is it a C1A that you can submit alongside a statement, or what's it called, a submission statement, or what do they need to apply with it? Let's talk in detail about the terminology of what they need to do, basically.
If you intend to challenge, if you intend to challenge a non-molestation, and as I say, and I encourage everybody to challenge a non-molestation, because, as I say, the implications of not doing far outweigh the benefits of challenging it. But there's a way to challenge it, and we'll talk about that in a second.
Okay, so just want to highlight, so regardless of how pointless it may seem, not after considering what we've said, still play the game and challenge it, you're saying?
Yes. Yeah.
Right, okay, sorry, carry on.
So, the way you challenge it is that, as I say, there potentially will be a form. Some courts use it, some courts don't. There'll potentially be a form with the non-molestation order that you fill in: name, address, non-molestation case number. Tick the box. What do you intend to do?
Is
Do you
there a
intend to
code
challenge?
or anything, or a name of the form? C1 isn't?
No, it's not. No,
there's
as
no
I
name, right,
say, there's no name. So it used to be called a C21. It's not anymore. It's now just because, I say, some forms don't, some company courts don't use it.
Okay,
C1A, which obviously you mentioned. What a C1A is it's a form that you complete if you wish to make domestic abuse allegations against another party. So what you can do, one of the options that is available to you is, of course, counter allegations. You've made these allegations against me, and as a result of that, you've been issued with an ex parte non-molestation order. I want to challenge that non-molestation order, and the basis of my challenge is counter allegations. So actually, no, it's not true that I hit the children. Actually, it was you who hit the children. It's not true that I controlled the finances. Actually, it was you who controlled the finances, and I can prove it. So a document like a C1A, and this is really where you need to sort of have a touch-based conversation with. Don't go to solicitors. Don't do that. Have a touch-based conversation with the likes of us, and get some guidance on what you should be filling out. The single most important part of a challenge, the written submission, is a statement.
Submission statement.
Yeah, you need to provide a submission statement that says, "This is why I am challenging this order. Let me give you my view, my truth about these allegations." And that is the single most important document that you will write. Let's stick with challenge for a minute, because obviously, if you're going into court and challenging, you are challenging the non-molestation. You are challenging the court. Because the court has issued this non-molestation. You are saying to the court, you are wrong in issuing this order. So when you challenge the court, here is the golden rule of challenging the court: be seen to be reasonable.
Right. Okay. So just to touch base and make sure we've covered it all. So you've got the non-moral. You've looked at the back. You're going to challenge it to discharge. Along with that discharge form, or whatever it is, you need to submit a submission statement. And in that statement, though, do you counter challenge the allegations made against you? So the statement of allegations that the ex has made against you, or she may be the ex now, I presume. Say the classic: you throttle me, threat to life, coercive control, financial abuse. Do you now counter each specific allegations in your submission statement, and also be reasonable in your submission of that statement?
Yeah.
Is that what you're saying?
Yes. Yeah. That your statement is you giving your version
of events
of the allegations that she's made.
Right.
She said he throttled me. Well, actually, what happened was this.
It was foreplay.
Or thank you. Or it didn't happen at all. And let's be honest, there are lots of occasions of that. Apparently. But as I say, so the statement is you giving your version, your truth about those allegations. Also, if you do want to counter allege, if you do want to make counter allegations against the other party, that is the document that you use to do it. Your
submission
statement.
The submission statement.
The statement.
Within the statement you do.
Within the statement you say, this is what I want to say about her or his allegations, and these are the allegations that I would like to make.
Okay, so where does a C1A come? Is that a separate form?
A C1A tends to be related. C1A is only as a child matter. This is where we start to get. This is where we
let's
start to
not
get
confuse you.
confused.
Okay,
As I
let's not
say,
confuse. So leave
yeah,
the C when they out of it. So look,
yeah,
all you
yeah.
need to do is tick the box to say, I want to discharge. I ain't
Mm.
having this. This is a load of crap.
Mm.
Fill out your submission statement. Counter all the allegations with your version of events, along with anything else that you may want to add. Be seen to be reasonable. And I think the sensible thing to do is do not just sling mud for the sake of it. Yeah, because I don't think it helps. It won't work in your favor, and you are just embroiling into this back and forth, which only the whole system will just feed off of that to look to make money. Especially if you've got a solicitor barrister, they will encourage you to do all of this. Do not do that. Do not fall for it. Every time you make an allegation, they make money. Whether you're doing it, she's doing it, they're making money, you're getting poorer, you're getting into debt, and your children are going further and further away into the distance. Would that be the good way to?
Yep, that is a good way. I say you are going to go into court and challenge this document. You are challenging the authority of the court. You need to be seen to do that in a reasonable way. Shouting and swearing in the court is not the way forward.
Just like I said, stay cool, don't sling mud. Now, okay, so father's filled this. He's written out a submission statement. Be seen to be reasonable, counter the allegation, put your version of events on there. Now, how do you get it over to the court? The submission statement and the form that they get. Do you do it by post? Do you email it back? Give us the little mechanics and the nuances of it for someone who has no idea.
Yeah. I always recommend, if you've got the physical form in your hand, if you've got if they've sent you the non-molestation order in the post, so you've got a paper copy. I always recommend that, number one, you take a copy of it. Take a photocopy of it, either down at the
document everything.
Yeah, down at the library or at work if you can, or however it is you can get it. But get a copy of it, even if you photograph it on your phone. And then, secondly, when you've completed the form that's on the back of it or accompanying it, again, photograph that form, document everything that you do, because at some point in 6 months' time, someone's going to say you didn't do that, and then you can produce a photograph or a photocopy or whatever it may be. So document. The family court lives and dies on paper.
Yes.
Then once you've done that, I tend to recommend two approaches. The paper copy, send it in the post, recorded delivery, in order that you have a record of the fact that it's gone. But at the same time, photograph it and email those photographs to the court separately. So the court is receiving your application, your challenge twice, electronically and in a paper version. And the reason we do that is very simple. The family court is overwhelmed with casework. The family court is overwhelmed, full stop. The family court is under-resourced. Family court is underfunded, which means stuff goes missing. Stuff goes awry. Stuff hits a pile of paper, and if we flash this camera around to my desk, it's a horrible example of it. But stuff hits a pile and then stays there for months on end, because other stuff takes priority. So doing something electronically and doing it by paper is the safest option, because you are doubling your opportunity for the court actually to acknowledge it and do something with it.
Right. So what Dan's basically saying is get organised. Get your shit together. Get organised. You need to, yes, it's hard, the turmoil, the pain, the anxiety, I know it. I know how it is, but pull yourself together, get your head together, get organised. Number two, do not overthink things. Your brain's going to be running at 100 miles an hour. Get a grip of it, get a control of it. Do not let it take over. Get focused, hold it together. You can get through this. Right, Dan, I think we've covered as much as we can really with the non-moles. Now, if you've got the non-mole, it's going to be stamped up for a year. This is the other bit maybe even I'm slightly unsure of. So they've got a non-mole. Non-mole said you can't go 100 meters within her. 9 out of 10 times she's in the family home. Why is then an occupation order applied for on the back of the non-mole as well? Explain that to me.
Okay, an occupation order is specific to the property. A non-molestation is zonal. So non-molestation says you can't go within 100 meters, and you can't go in the street, and you can't go to the school, and you can't go to the local supermarket. It's zonal. Mm-hmm. An occupation order is property specific. So an occupation order says that you, as the person who has had this occupation order land on you, cannot enter the family home or the nominated address, but obviously 99% of the time it's the family home.
Where you guys were living here together. Yeah.
You cannot enter the family home. So sometimes you can actually get an occupation order without a non-molestation. So you actually get an occupation
Okay.
order that says you can't go in your own house. You can stand at your garden gate and shout and swear all you like, but you cannot go in your own house.
Okay, so they are independent
They are
from
two
each
separate
other.
two
Okay,
separate court vehicles,
fair enough. Okay.
often served as a set, often served as a duel. Get one, buy one, get one free. Yeah, so an occupation order is specific to a property, stopping you from going inside and occupying a property. Occupation order. A non-molestation order is zonal. A non-molestation order relates to a person. So you can't go near this person. You can't go within 100 meters. You can't go in the same street. You can't go in the same supermarket. You can't go in a house that they may well be in. That's the difference between the two.
Okay, but the rules of the occupation order. So let's say you got an occupation order, but not a non-molestation order, for argument's sake, yeah. But your equipment, your clothing, you've got nowhere else to go. You're homeless. You can't take it with you. You've got to stay there. Is the process still the same? So you can ask to discharge, vary, or accept. The process is still the same as the non-mol as far as challenging it is
Pretty
concerned.
much, yeah. Pretty much, it's a very similar vehicle. So yeah, you get the opportunity to challenge it, and again, you get the opportunity to take an undertaking where you say to the judge, "Well, look, I don't accept it. I don't accept the allegations that are being made that are resulting in me having this occupation order and not being allowed to go back in my own house. But I will not go in my own house as a promise to this court without, and it's called without findings. So I'm not taking liability for it, but I promise this court that I won't go in my house." So yeah, all the variation,
Okay.
acceptance, challenge, all those options are still there as in the non-mol.
And I presume if you tell the judge, I've got nowhere to go for 1 year. Where do I go? I mean, he's basically the same rules apply. Sorry, bud. I like you. I believe you
Yeah.
even. I think you're actually innocent, but I can't do nothing for you.
Yeah.
Same rules apply.
Yeah.
So
Yeah.
basically,
Yeah.
you need to pull yourself together. You're now in the trenches. Once you've had these documents served on you, you are officially in the trenches. Your job is now to survive. So I would say harness your energy instead of the anger and the frustration. Harness your energy into the longevity of how you're going to survive and get through this. That is my advice to you. Right, what else did we not cover? Okay, just quickly, just if we could touch on it now. When a father, and this is where it all coincides, as you said, one order to the other to the child access. Because father now, once he has these things served on him, he's 5 steps behind. He's potentially on the back foot. And I mean, the reality is going forward, he's now the non-resident parent going forward for more than likely the rest of his children's life, as sad as it is, right? Yeah. What is he to do at this stage to say, right, how do I see my children? What should they do now at this stage? What form, what application, best approach?
If no application has been made at that point in terms of the children, because just a little point of clarification, the family law, the family court operates two systems of law. It operates family law and it operates child law.
Aye.
And they are separate. So if we look at, so far during the course of this broadcast, we've been talking about a non-molestation order, and an occupation order. Non-molestations and occupation orders are family law matters.
Right.
Dealing with getting access to your children and getting to see them in their nativity play, or getting to see them on a Saturday afternoon at McDonald's or whatever it may be, that is a child law matter.
Right.
And the court in a hearing will not deal with both of those matters at the same time.
Okay.
So the reality is, if you've now got your non-molestation, whether you've managed to get it kicked out or whether you've got it in your hand, either way, if there is no application at that point for the child matter, if at that point there is no formal start been given for dealing with the children, then you have to launch an application.
The C100.
Thank you. The C100, and that's where we then come back to the C1A. And I'm sure we can have there's a whole broadcast around the joys of the C100 and the C1A and MIAMS and pre-application mediation, etc. There's a whole subject area there.
Okay, so just to keep it simplified, and this is where the problem is. You've got this non-mol on you potentially. We know what the occupation order is. Normally it's handed side by side. You're homeless, along with the non-mol rules apply, and you can't go home. So it coincides, like I said, dual sort of functionality. Now, in that automatically disqualifies you from your children's life. You're automatically a disqualified dad. So at that stage, like I said, there's no starting point of when am I going to see the kid. You can't talk to her. You don't want to risk talking to her. You don't want to risk approaching them. More than likely, you're probably not going to see the children. Obviously, it's in mum's interest not to give you access because she's a resident parent, and for her to gain control, child maintenance, all of that. The chances are 9 out of 10 times, unless she's a good woman or a good resident parent, you're not going to be seeing the kids, and you've got no one to even have this conversation with. Hence, at this stage, you need to be looking to file a C100 application. Now, again, do not go to a solicitor or a barrister. They will play on your emotions and your fears, and that's another $5,000 right there. You're already 10 grand in debt. You're homeless. You're potentially struggling to survive. You're on the streets, and now you're 10 grand in debt. Don't go to these people. They're sharks. They will finesse you. C100, just to clarify, you could go online, have a look at the form. You go online, they'll give you an example of how to fill it out. Now, just want to clarify one thing. You know, on the C100 application, when you're filling that in, there's a box to say, is there, like if you want to sling mud at the mother, there's a box to tick. What's it called? Mental health or abuse? Are you concerned about abuse with the children? Now, obviously, look, you know, these situations are emotional, they're tricky, and there is an urge, or because you've had all these allegations placed against you, there is an urge to say, well, guess what? Like you said, I've never hit the kids. She was home. She used to take them to school. She used to do the discipline. She's the one actually hitting them. She's the abuser. There is an urge to want to tick that box, to fire one back, to even out the playing field, which I can understand that, you know, it's understandable. Should they do that or not? Especially if we're not talking about discipline. There's no real abuse. Just like the allegations against you, it's all a bit dramatic and over the top. It ain't real. It amounts to absolutely nothing. What is advisable here?
Unfortunately, there is no set answer. Every case is different, and every case carries its own unique idiosyncrasies. So I will sit with a client and say, we absolutely need to start raising some counter allegations and start challenging and start accusing. We absolutely need to do that. And in another case, I'll sit and say, well, okay, I hear what you say. I accept the point. I accept the fact that, yeah, maybe mum or indeed dad haven't been great, and they've done some stuff that maybe is not ideal. But our opportunity to reach the end goal, to reach the finishing line, will be better served if we are seen to be reasonable and if we are seen not to counter accuse. So it is entirely driven by the case.
Okay, fair enough.
So there is just no set answer to that.
All right, we won't go too much into that. Just to clarify, that is case by case basis. And what I would say to that is you need to reach out to people like us, and we can look at your case and we will draw up a game plan and how to proceed. But rule number one, again, let's go over it. You need to be patient. You need to be patient, keep a cool head. Do not react emotionally. Control yourself and hold it together and survive. That is what you need to do now, and send in the applications and the forms that we've talked about. That's what you need to do at this stage. We are going to continue to put out these educational videos to help all of those who are struggling and suffering once they enter the system, and those who are not in the system learn this stuff. You've brought children into the world. You're in a relationship. You need to know the law. You need to know the society we live in and the systems we are operating under. And to keep this channel going, keep this information going, you need to subscribe. Subscribe, like, follow, and share. There's more videos to come. The next video we will make, we'll go on to the C100 and the application and what to do and how the next steps will unfold. Thank you for watching Disqualified Dads. Dan, is there anything you want to put out there?
One final word of caution. Non-molestations have an expiry date on them. That expiry date is 12 months from the day it was issued. But let me tell you this. Non-molestations never go away. When it's expired and you are 2 years into your proceedings, they are still going to raise the fact, oh, I see you've had a non-molestation in the past. You are going to carry that label. They may as well issue it on a t-shirt. The non-molestation will never go away.
Hence, you become a disqualified dad. Thank you for watching. Like, subscribe, share.